Welcome to the I Now Pronounce You Divorced podcast, where we have three award-winning family law attorneys dive into intriguing topics like divorce, military divorce, custody and visitation, trust and estate planning, and all things family law. Join us as we provide a comprehensive viewpoint through the eyes of our experts and guests, aiming to educate and soothe our listeners. Get ready to tune in because I Now Pronounce You Divorced starts right now.
Hi, I'm Charles Hatley with Malone Hatley PC, and this is our podcast, I Now Pronounce You Divorced, where each week, Dan, Rebecca, and I come together and talk about things that we see our clients and our team members going through that we believe will be really good information for anybody who's going through divorce or thinking about divorce. So today, we were talking to a lot of our team members through what we call our MHU about depositions. And in family law and civil litigation, depositions in family law are not very common. In civil litigation, they are very common. So Dan, can you walk us through what a deposition is?
Sure. Depositions are usually a tool, a fact-finding tool. And why I like them is because the rules of evidence are a little bit more relaxed in that environment. And it's a wonderful opportunity to really just ask as many questions as you can to try to figure out what are the issues, what are some of the underlying issues. And then from there, it may lead you down a rabbit hole or it may lead you down another path that you didn't even think to explore because of the answers that you're getting from the questions that you're propounding to the witness. But just at kind of a high level, the deposition usually will take place in either one of the attorney's offices, and then you'll have a court reporter who is someone that's there that is essentially just recording everything that's being asked and answered. And then usually you'll have both parties there and then their attorneys. And it'll start off with whoever sends the notice of deposition will ask the questions, and then the other side will get an opportunity to be able to ask substantive questions or do follow-up questions. And then at the end, you get a transcript. Usually could take maybe a couple of weeks to a month, depending upon how busy the court reporter is and when you need it by. And then it's a wonderful tool to use to try to resolve the case. Because in my experience has been, if you're at the point where you're taking a deposition, there may have been some settlement discussions, or maybe this is a tool that will help facilitate that. I'm always a big fan of them because I never want to go to any hearing or especially a trial without knowing what the other side's going to say. To me, besides being able to ask a little bit more general questions and have those rules of evidence a little bit more relaxed, it's also a wonderful tool to kind of peek behind the curtain to see what is that witness going to testify. How do they look on the stand? What are they going to come across if there's a jury? Because there are states out there and family law cases where there is a jury. Most times just a judge, a bench trial, but you get an opportunity to see what will this person look like as a witness, whether it's the other side or it's your client. Because if it's my client, that gives me an opportunity. Okay, I need to work on this. Maybe it's the way that my client is speaking or the way that they're coming across or the answers that they're giving. And so it's a great opportunity to kind of rehabilitate that person, but also know where our strengths and weaknesses lie. And then at the end, once we have those depositions completed, then I meet with the client to figure out, okay, here's where our risks are. Here's some of what the exposure is. Let's draft a settlement based upon what happened, and let's see what we can do from there.
In our MHU this morning, I told the attorney, I said, the only bad deposition is the one that didn't happen. I said, literally, no matter how bad you believe that the deposition went, you got to, like you said, Dan, peel back the curtain a little bit, and you never know what's going to come out. Even if what comes out is that my client is terrible on being questioned. And that way I can sit my client down and say, look, you weren't good at it. Let's be honest. Let's work on this. And, Dan, you brought up, jury trials in Texas. There are jury trials for family law. And even judges, even if it's not a jury, a judge is looking at you and judging you, obviously, the whole time on how you're acting. So, Rebecca, can you kind of walk us through in what instances do you think depositions are most important?
In family law cases, it's whatever the sticky issues are. So if you have a case where everybody's really contesting custody, you might want to do a deposition all about custody and the best interest of the child. And, what are the living situations? How are they going to testify about their relationship with the child? All of those elements. And you get that opportunity to see what their answers are. Sometimes you get the opportunity to find out what they really want, because before this, all of the conversations are likely between the two attorneys. And if you have the other side in the room and you can say, what is it you want for a custodial schedule, you might get that much closer to resolving whatever the issues are, wherever those gaps are. If the issues are more about the financial side of things, so we have a case going on right now where someone is using money and we don't know totally how or why or what's going on, right? And so we have some records and we know that money's going out, but we don't really know where. So we need to get some more information. Who are you sending money to? Who are you employing? Why? What job function are these people doing? And it just gets you another step further towards getting the information. And then you have enough to know whether we do want to settle this or whether this is something that we need to take to trial because he's now spent hundreds of thousands of dollars and done marital waste. So it really comes down to the particular issues in the case. A lot of the time, depositions will be about adultery, if there's a case that involves claims of adultery, because it gives an opportunity to outright ask the other side, did you cheat with this other person? And, what's your relationship and when did you see them? And you can get a lot more information that way. In Virginia, if someone sits there and pleads the fifth, they say, I don't want to answer and I'm going to plead the fifth because adultery is technically a crime here. Well, now we can take that as a negative inference against that person when we go to court. So it just gets you one little step closer towards proving your case. It gets you one step closer towards finding the information that you need. And it may get you closer towards settlement if that's where you're going. But it at least prepares you so that when you go to trial, you're not talking to this witness for the very first time and being surprised at what their answers are. You never want to be surprised when you're in a courtroom in front of a judge.
No, a good attorney, I'm not going to say a great attorney, a good attorney will not show up to court to surprises. Prepared attorneys show up to court to surprises. You brought up a wonderful part of deposition is it's an opportunity for the two people who are involved in the controversy, generally the spouses, to sit in a room. I had a deposition one time. It was a case where my client was promising me, look, I know my wife's not reading the settlement offers we're sending over because she would have accepted the settlement offer. I know she's not reading it. And there was a little bit more going on. Like we'd send a settlement offer and 15 minutes later, we would get denied back from the other. It's like, but it's 50 pages long. How did you even read this in 15 minutes? And literally it was timestamped 15 minutes. We used the deposition. I had the wife sit down and read the settlement agreement and say, tell me which part of this you do not agree with. And the other attorney objected vociferously, so angrily objected to it. And so in most jurisdictions, when there's an objection, you can call an on-duty judge and clear up the objection. The judge was like, this isn't objectionable. So the other side sat there and said, I agree with everything. And I said, would you be willing to sign it today if my client signed it? And she was like, yeah, absolutely. I'll sign it right now. I don't know if that's allowed because that was weird. There's a lot of things I was skirting on there, and I actually called the ethics hotline on myself afterwards, and they're like, yeah, it's allowed, but it is weird to do that. So Dan, what do you like to use depositions for?
I like to use them as a fact-finding tool because the way that I prepare for depositions is I always want to send out discovery first, because I'll review the discovery, see what's coming in, anything that doesn't seem right to me, or if there's any items that are missing, ask questions about that. If there's any objections, try to clear those up during the deposition. And then I'll meet with my client ahead of time just to kind of get a better idea of what's going on. What are the goals that my client wants if we don't know what those are, or maybe we need to redefine those. And then kind of lay out the rules of the game for the deposition, because they can get pretty heated. I've been in some where we had to take many breaks because since you have both parties there, a lot of times emotions are running high, and we just need to make sure that cooler heads prevail. And we want to get through the deposition and not try to delay it and then maybe have to reschedule or just end it abruptly. And so I always want to walk my client through, and this is what you can expect, and this is what may happen. No matter what you hear, no matter what is said or written down, just be quiet. Write me notes if you need to. Kick me on the table if you think that there needs to be a break or something like that. Because we want to make sure that, one, we're professional, but two, we want to make sure that we have the other side comfortable in answering questions. Because once they're on the defense, it's hard to get them to go on the other side. And so I try to really kind of open up the depositions with just making the person feel relaxed. What is your name? Where do you live? What is your occupation? And if you have kids, how many do you have? And then kind of just lead them down that path, and then start asking a little bit more direct questions. And so I just want my client to know that ahead of time. So he or she is thinking, well, what the heck are you doing? You know, all this information, you're wasting my time. It's in the pleadings. So I want them to know the purpose of why we're asking certain questions. And then I'll submit a draft outline to the client ahead of time, just so they're aware. And I want them to weigh in. I want them to say, yeah, this makes sense. Let's follow up a little bit more on this. Or, you know, maybe they don't want to ask a certain question. Then it's okay, well, why not? Because maybe my client, to your point, hasn't been completely forthright with me. And I need to know that, because I've been in depositions where a question was asked and I was just thinking, I don't even know where this is coming from. This is coming out of left field. So I don't want any surprise, because the more that we know as lawyers, the better we can really position ourselves to defend or at least mitigate some of that potential exposure. And then once the deposition is concluded, I'll get a copy of the transcript. I'll send it to the client, and then I'll set a meeting to review it with him or her to go over where I thought the strengths were and the weaknesses were, things that we've been talking about through this podcast. But I think it's a wonderful tool. I always use them. I advise any attorney that I work with to make sure that they at least schedule depositions. Not every case will need it, because you may be able to settle ahead of time, but really kind of holding the feet to the fire. In my experience, a lot of practitioners do not like depositions. And then a lot of practitioners don't like even going to trial. So it's kind of like the last step before you go to trial is getting that deposition, because you're locking that person in. And I've had a couple hearings to where, you know, you can use depositions to impeach. And I remember this one trial I was in, it was a multi-week long trial, and we were going through the deposition, and what they were testifying in the stand was completely opposite to what they were testifying in the deposition. And in both instances, you're sworn and you're supposed to be telling the truth. So if you're under oath and you're telling the truth, they really should be in sync. And so when they were contradicting what was said in the deposition, I just simply asked, well, can you please let the court know, were you not being truthful during the deposition, or are you lying today? I just want to get the record straight. And then the trial ended and we settled. So they are really wonderful tools.
You know, it cannot, that's what we were talking about this morning in kind of our mentoring session, was you're setting up the ability to be able to attack the veracity of the witness, the truthfulness of the witness. Because, you know, anytime you put somebody under a high pressure situation like a deposition and then follow that up with litigation, they may change their story. And what's even more likely is they tell the story one way at deposition. No, I don't think any attorney would ever advise anybody to lie, hopefully. But then the client realizes, the opposing party realizes that was not a good way to say it. So then on the stand, now the story is completely different. Like, oh, no. I didn't cheat on my wife. I was in a texting relationship, you know, and you're like, but your deposition said that you had, you know, intercourse with this person. You know, one time I had a deposition where it was meant to be very intimidating. So the wife was basically a Craigslist prostitute. And so in like the course of 3 or 4 months, she had slept with 14 guys. So I subpoenaed the 14 guys and had them sitting in the lobby while she walked in. So I subpoenaed them to be there at 8:30. She was supposed to be there at 9. So when she walked in for the deposition at 9, she saw her 14 paramours sitting there and waiting. And she was the first person I deposed. And I said, have you ever cheated on your husband? And she looks out in the waiting room and all 14 of her paramours are sitting there. We settled that day. We actually settled before those guys were able to come in and testify. But Dan, like you said, it doesn't always have to be such a controversy. It doesn't have to be a fight. So Rebecca, can you kind of walk us through how you're not a jerk to the other side and how you tear down that wall and say, look, we're both people. I have some questions to ask you. Let's just talk.
Right. So keeping a cool head, like Dan mentioned, is really important. And even if you know somebody is not telling the truth, you don't raise your voice, you don't call them names, you don't say you're a liar, right? You just move on to the next thing and you point out whatever it is that you needed to point out. The deposition, it's not a trial. There's no judge sitting there and making a decision based on what's going on. So if you don't get the answer that you want, okay, you go back and you approach it another way. You don't need to attack that particular phrasing. You don't need to attack that particular thing. And so you can keep it a lot more cordial and you can keep it a lot more sort of relaxed and casual in terms of the conversation, and you'll probably get a lot more information that way. So if you do exactly like Dan described, just walking them through some of the easy stuff and, tell me about your kids and how old are they and, what are they doing at school and do you have pets? And just do some easy stuff and get them used to answering some questions first before you get into the more difficult things. And you don't have to have these like gotcha moments, right? It's not all about gotcha. It's let me just ask you the question openly, and depending on whatever that answer is, we'll maybe continue on this track or maybe we'll go somewhere else. I don't have to show all my cards either, right? I don't have to say, oh, but I have proof that you did talk to this person. I can just take them at their answer. And they said no. Okay, great. Now I have this transcribed and I'll bring it and I'll use it as my gotcha moment later in court. So I think that's an easy trap that practitioners can fall into, is sometimes I know that they're lying and I want to have that, like, oh, but I got you and I have this piece of evidence that's going to prove you wrong, or I have this photo. And you don't need to do that in a deposition. We're just here to ask questions. We're here to get information. We're here to find out more. And then I can do further discovery. I can issue additional subpoenas. I can interview other witnesses. And I can come back and attack the truth of that statement later on. I don't have to do that right now today.
That's, I love what you said. You don't have to play your hand at the deposition, right? There is so much value in saying less than there is in saying more. And I know that we've all fallen victim to watching television shows with attorneys where I always liked Matlock, where all of a sudden, Matlock's running around, he finds the murder weapon on the eve of trial. And it's like, gotcha. It doesn't happen that way. It happens through methodical preparation, like both you and Dan said, of, hey, I did my discovery. I asked these questions. I actually found out where you lied to me and I pulled it back. That way, when it comes time and I need this piece of evidence, I've got it. So, Dan, depositions aren't free. How do you talk to a client, somebody that you're working with, and show the value of the deposition?
That's a good question, because they can be very expensive, and it depends on the court reporter and their costs and who you're deposing and how long that's going to take. My thought process behind it all is advise a client, this is a tool that we need in order to continue to build your case. You never want to go to a hearing or trials, as we discussed, without knowing what's going to be said, because the minute that happens, the case is going to be over, or we're going to expose a lot of issues that we could have resolved or at least mitigated ahead of time. It's more of an insurance to make sure that we're moving your case forward, but in the right manner, because at the end of the day, one of the best tools that we have to be able to represent you is taking that deposition, and it's money well spent. And we want to be able to maximize that time. And we can maybe save a little bit and shave off some costs if we depose both parties at the same time instead of having to do it on separate days. I always like that anyway, because that gives the other side a greater opportunity to prepare if we kind of bifurcate and do it one day and then the next day or however long thereafter. But I always want to prepare them ahead of time. Once I know that we're approaching sending out a notice of deposition and trying to get it scheduled, I'll have discussions with the client to be expecting, we may need to replenish trust account a little bit more. These are some of the issues that we discussed in the beginning, and it all goes back to communication. I know we've done a lot of podcasts on communicating with clients, whether it's on this podcast or other podcasts, the Business Blueprint. We just want to make sure the clients are aware, and it's setting that tone in the beginning. This is what you need to expect. If we can't resolve your case within a certain amount of time, then here's our next step. Just kind of letting them know what's next. It's so important. So when you have that discussion, okay, it's time to start really thinking about a deposition, and this is why we want to do it, then we may need to increase some of your trust account or replenish it a little bit more. I always say prepare for a half a day to a full day, depending upon how many individuals are being deposed. But then you want to add prep time to that too, which usually may be an hour or so for every hour, hour and a half for every hour that you're in a deposition. But the client's part of the process too, so they can not only be involved, but then they know that the amount of time and the effort and the work that's put into it. Plus, as all of us have discussed, depositions usually will lead to some type of facilitation of settlement. Way better to invest your time in a deposition and try to resolve it than have to prepare for a trial, go to a trial, have a judge who has really no emotional interest in your case, except their only vested interest is to resolve it and then move on to the next one. And then you're kind of at the mercy of the court. So there is just so much value within a deposition, but there are times to where clients can't afford it. And then it's really trying to figure out, okay, what is the best tool that we can use to be able to represent you? Usually in those situations, the other side is kind of in the same boat as far as costs are concerned. But maybe it's another opportunity, depending upon the jurisdiction, you ask the court for legal fees, and then you really kind of specify exactly, this is what I need them for. So my client or the other side has a fair opportunity to be able to present their case.
Yeah, the case we were talking about in our mentoring session this morning is exactly that. We went to court and got $30,000 in advanced attorney's fees because the discrepancy in income was so large. In order for our client, and especially it's like business and everything else, in order for them to be able to survive in this fight, the court saw the necessity of doing these. And to the court's credit, when we said we need to do a deposition, the court was like, yes, you do. And I'm going to issue an order to where the other side has to pay for it, because even the judge saw the importance of entering a ruling that the deposition needed to be paid for. Dan and Rebecca, I want to thank you for joining me in part 1 of depositions. Next week, we're going to talk about how to prepare for a deposition, what to expect from the other side of the deposition, and what to expect from your attorney when you're being questioned in a deposition. So if you like this episode, please click like or subscribe. And if you or somebody you know is going through a divorce, contact a partner you can trust with Hadley PC for the help to get you through this process.
Hi, this is Dan Cuneo with I Now Pronounce You Divorced. Thank you for taking time to listen to this week's podcast. Please join us next week for part 2.
Thank you for tuning in to our podcast. If you found this episode helpful and you want more informational content, please be sure to subscribe and join us on all major social media platforms, including YouTube. Stay connected for more exciting updates and tips.